Good morning, Jackie Broman here from TBA Law, doing my Monday morning Facebook Live. So, today I wanted to talk about the rights of beneficiaries after someone passes away. So, firstly, who is a beneficiary? So, a beneficiary is someone who receives a gift or a benefit under a will. All right, so it's not extended family members who get nothing under the will. The beneficiary is specifically named in the will. I've previously spoken about family members who need to make a claim against a will who aren't beneficiaries, okay? So, a beneficiary is a person named in a will. Now, beneficiaries actually have fairly limited rights, really. From a solicitor's perspective, I'm generally acting for the executor. So I don't act for the beneficiaries. The executor has legal responsibilities to act in accordance with the law and to distribute the estate in accordance with the will. So I'm bound by the law and the will, and I need to help the executors through that. I am not there to provide legal advice to beneficiaries. So beneficiaries may have to go on and get their own separate advice. So beneficiaries should be aware of that approaching the lawyer who's acting for the estate may be a tricky thing because they are not necessarily acting for you, or they're not acting for you. So there could be a conflict in them trying to provide you with legal advice. So that's the first thing. Now, there's three main things I think that beneficiaries need to know. The first is about the length of time that an estate takes and how long it's reasonable for an executor to be doing their job. So 6 to 12 months for an easy estate, I think, is fairly reasonable. So beneficiaries shouldn't start jumping up and down if it's still within 12 months. 12 months to 2 years is still reasonable in some respects, particularly if there's real estate, right? So real estate keeps its special tax definition or status rather as the principal place of residence of the deceased for 2 years for most taxes, right? So if the executor for whatever reason can't sell the place quickly, or there's other factors that need to be dealt with, having an estate still not wound up after 12 months, but within 2 years is reasonable as well. So again, beneficiaries shouldn't start jumping up and down. If the estate is complex, so long as the beneficiaries are getting some information about what has been dealt with and what hasn't, then that's reasonable as well. So that's the first thing, the length of time. It's not going to help things necessarily by continuing to contact the solicitor for the estate or the executor asking what's going on, okay? You can, so we're sort of getting into the second thing of what you're entitled to. You're entitled to certain levels of information, but not everything. So if you're in the will, you're entitled to a copy of the will. No, there is no reading of a will in Australia. It's an American concept. If an executor wants to sit down and read the will through with you, that can be done, but again, it's just not a tradition that's done here, and it's not a legal requirement for certain. So beneficiaries are entitled to a copy of the will. Beneficiaries are then entitled to know roughly the value of the estate if they're a residuary beneficiary. If they're only getting a legacy, they're not. An executor also has to account to a beneficiary only with what assets they've been able to bring in and what debts they've been able to pay, they've had to pay. So they have to provide information about their accounting, basically. And under certain circumstances, an executor has to provide copies of trust documents. Okay, now that is fairly narrow, so there's not necessarily a lot of information that a beneficiary gets, because having said all that, a beneficiary is supposed to trust to a degree that the executor is administering the estate in accordance with the law. So when a probate is granted to an executor promises to do that to the Supreme Court. So if a beneficiary suspects that an executor is not, they have to go to the Supreme Court, and the executor has to account to the Supreme Court, all right? The executor does not have to answer to the beneficiaries. The executor has to answer to the court. So that sort of comes down to the final third set of information for a beneficiary, and that is how to work with an executor. So as I said, the executor is accountable to the court, and they have to act in accordance with the law. They do not have to take instructions from beneficiaries. So an executor is pointed to a role by the person who's passed away for a reason. They want that person to administer the estate. And other people who are beneficiaries have also been excluded, hopefully for a reason as well. If there's family dynamics that don't allow for a smooth administration of the estate, the executor has been appointed to that role to manage that situation. So when working with an executor about where an estate is up to, again, you're entitled to certain information which you are allowed to ask for, but you can't be trying to direct the executor getting certain values for assets. You do not have a say in what happens to the household items. The executor has full discretion to deal with what's in the house. The executor is allowed to change locks on the house and secure the house. In fact, that's their legal responsibility, to secure assets and keep them insured. So it can be a difficult situation being a beneficiary who's sitting back, particularly if a beneficiary is someone who's quite competent and likes to be in control. They have to really just let the executor run with the job, trust that they're doing what they need to do in accordance with the law, and if you really think that there's a negligence in what the executor's doing, you need to go to the Supreme Court. There's no point jumping up and down to the executor that they're not doing their job, because they don't have to account to you, they need to account to the court, okay? So that's some quite frank advice to beneficiaries. So firstly, the time frame that you need to be thinking about for how long an estate's going to take. Don't start spending your inheritance before you get it. It can take 6 to 12 months on a simple estate, 2 years on an estate with real estate, and beyond 2 years where it's complex. The second thing is, what level of information are you entitled to? So as I said, not particularly much. You're not entitled to know the day-to-day operations and administration of the estate. You're only entitled to be accounted to in terms of dollar figures and what's been got in and paid. And then thirdly, how to work with an executor, particularly what you can expect to the input that you can expect, or rather the lack of input, because you don't really have a say at all. So it is really best if it's possible, if everyone stays on a basis that they are working together towards getting something done and working cooperatively. But as you can imagine, there are many families where this can't happen, and therefore beneficiaries just need to sit back and wait, essentially. So that's some guidance on the rights of beneficiaries. There's very little, really. If you need to enforce anything, you need to do it through the court. And if you think that the estate's not getting administered in accordance with the law, again, you've got to go to the court. So if you want further information as a beneficiary, I do have a guide for beneficiaries that you can download from the website. It's 7 pages long or so, so it does cover off a lot of information. If you have more specific questions you want to ask, you can direct message me through Facebook, or again from the website you can find our admin email address or my email address directly. So again, my name was Jackie Broman. I do this short Facebook Live every Monday. So if you want to tune in, we announced the topic the previous week, and I'm here for 5 to 10 minutes every Monday morning. So I'll see you again.